Good afternoon, ladies and gentlemen. Thank you for joining us today for this important event, Reforming the MACC, a roundtable on current issues, obstacles to progress, and ways forward, organized by the Center to Combat Corruption and Cronyism, or C4 Center. Uh, the roundtable will begin shortly. Due to some technical difficulties, we are still letting some of our participants into the Zoom room. So thank you for your patience. But before we begin, I'd like to go through some housekeeping announcements. Firstly, please kindly change your name and include your organization. Please use the raise hand icon if you wish to ask a question or give comments in person. Please mute your microphone unless you wish to ask a question or to give comments in person. We would also like to ask that you please keep your cameras on through the event. There will also be a discussion session after each presentation, and the questions can also be sent via the chat box. This roundtable will also be streamed live on our Facebook page, facebook.com/C4 Center, though we will not be taking questions from our public audience. Thank you. Once again, I'd like to mention the housekeeping announcements for today. Kindly change your name and include your organization. Please use the raise hand icon if you wish to ask a question or give comments in person. Please mute your microphone unless you wish to ask a question or give comments in person. Please keep your cameras on throughout the event. At our discussion session after each presentation, questions can be sent via the chat box. Once again, this roundtable will also be streamed live on our Facebook page, though we will not be taking questions from our public audience. Her Excellency, the Ambassador of Switzerland, members of the diplomatic community, leaders of civil society organizations and NGOs, our distinguished speakers for today, Mr. A.G. Kalidas, President of the Malaysian Bar, Ms. Cynthia Gabriel, Founding Director of C4 Center, and Mr. Francesco Cecchi, Anti-Corruption Advisor with the UN Office on Drugs and Crime, distinguished guests, members of the media, ladies and gentlemen, and to our viewers on Facebook. A very good afternoon and welcome to our event today, Reforming the MACC, a roundtable on current issues, obstacles to progress and ways forward, organized by the Center to Combat Corruption and Cronyism, or C4 Center. Thank you all for joining us. My name is Arif Hamizan, a legal researcher at C4 Center, and I will be your MC for the event today, and I'll also be moderating the discussion for our second session today. To give a little context to today, I'll give some opening words. In 2015, the Malaysian Bar, in collaboration with C4 Center, the Institute for Democracy and Economic Affairs, Citizens Network for a Better Malaysia, and Transparency International Malaysia, submitted a joint memorandum to the government setting out proposals to reform the MACC for it to comprehensively address and deal with corruption. The 2015 memorandum propounded that MACC's limited success in eradicating corruption in Malaysia was a result of corruption not having been addressed in a comprehensive and consistent manner. However, 3 administrations and numerous promises later, we are still yet to achieve much in realizing these reforms. What has hindered this progress? What have been the challenges for government and its institutions to implement these necessary changes for the MACC? And how can civil society play a more active role in these reforms? These are some of the questions we hope to open up and discuss today with the goal of reinvigorating our efforts to reform this institution. We have 2 sessions today. The first will be on re-evaluating the 2015 memorandum for the reform of the MACC, presented and moderated by Ms. Cynthia Gabriel, Founding Director of C4 Center. The second session will be on insights on the effectiveness of anti-corruption agencies and some best practices, with a presentation by Mr. Francesco Cecchi, Anti-Corruption Advisor with the UN ODC, and the following discussion session will be moderated by myself. In our discussion sessions, we look forward to hearing insight from each and every one of our diverse group of participants on all of the topics. So please feel welcome to ask questions, contribute thoughts, and really come together for a lively and productive conversation. Without further ado, to start today's program, I would like to invite Mr. A.G. Kalidas Krishnan, President of the Malaysian Bar, for his keynote speech. Thank you.
Thank you, Arif. A very good afternoon to Her Excellency Andrew Ashlin, Ambassador of Switzerland, Cynthia Gabriel, Executive Director of C4 Center, Datuk Sutina binti Sultan, Board Member of the C4 Center, Francesco Cecchi, Anti-Corruption Advisor of the UN ODC, Dr. Punita Selvaraju, Director of Policy and Research of Bahiu, distinguished leaders of civil society organizations and NGOs, honored speakers, members of the media, ladies and gentlemen. Today's theme, that of reforming the MACC roundtable on current issues, obstacles to the progress and ways forward, is a matter that is close to all our hearts as Malaysians. Thank you for letting me share my thoughts with you here today. In 2015, the Malaysian Bar, in collaboration with C4, the Institute for Democracy and Economic Affairs, IDEAS, Citizens Network for a Better Malaysia, CNBM, and Transparency International Malaysia, submitted a joint memorandum to the Malaysian Anti-Corruption Commission, setting out our proposals to reform the MACC for it to comprehensively address and deal with corruption. The purpose of the memorandum was to propose comprehensive reforms to the MACC and to find ways to effectively stamp out corruption in our country. Several years have passed and unfortunately, corruption is still rife. And I think the time is ripe to discuss what needs to be further done to remedy this perennial problem that has become endemic in our society. Allow me to share some numbers with you. Last year, 71% of Malaysians surveyed think that government corruption is a big problem, according to the Transparency International's Global Corruption Barometer. This is steady concerning increase from 59% back in 2017. Transparency International's barometer also breaks down other categories of abuse, including bribery rates, where it is disheartening to note that even our public schools are not spared from corruption. Even at 8% in 2020, the fact that it happens at where we send our children to be molded into upstanding citizens of Malaysia is a sign that the Malays that we have been mired in for too long is beginning to shape our future. Our current news cycle is filled with news regarding corruption. Just last week, Malaysia scored 45% and received a D rating in the Government Defence Integrity Index (GDI) for 2020, released by Transparency International Malaysia. This D rating indicates weak institutional resilience to graft, and it was only back in August when the Malaysian Bar viewed with deep concern the statement made by the then Prime Minister Muhyiddin Yassin that he had been receiving pressure from particular parties to intervene in court matters as a way to exonerate several unnamed individuals from criminal charges. Ever since the former World Bank President James Wolfensohn coined the immediate phrase "cancer of corruption" in 1996, we have no shortage of imagery to describe the deleterious effect that the corruption have on society. The former UN Secretary General Kofi Annan once aptly said, "Corruption is an insidious plague." This analogy is thrown into even sharper relief in our post-pandemic society where if corruption were to be left unchecked, will not merely undermine democracy and the rule of law, but also leading to violation of human rights and the erosion of quality of life. To put it simply, corruption truncates human rights because it gives certain citizens an unfair advantage over another. It ultimately subverts equal access to rights and opportunities that should be available to everyone and not just a select few in society. It siphons away resources from their intended purposes, thereby stifling growth, prosperity, and development. The role of MACC. This brings me to the main topic of our discussion today regarding the organization that is tasked with eradicating and stamping out corruption, the MACC. According to its vision and mission statement, the MACC aims to create a corrupt-free Malaysian society and to eradicate corruption, abuse of power, and malpractice in Malaysia. It seeks to concertedly and continuously strengthen integrity and enhance expertise through human resources development programs. In essence, the MACC aims to play a critical role in helping to realize a corruption-free, prosperous, and law-abiding society. Alas, this has not been the case. In recent months, the MACC had arrested 3 of its own officers after the former Malaysian External Intelligence Organization Director General Hassanah Abdul Hamid lodged a report that a large sum of cash, ringgit Malaysia 25 million to be exact, that was seized when MACC investigated her in 2018 went missing. It was reported that the 3 suspects were part of a special investigation unit that handled Hassanah's case. This is but the tip of the iceberg. There are still many structural and constitutional flaws within the MACC itself that have not been sufficiently addressed since the submission of our memorandum in 2015. Ladies and gentlemen, The MACC falls under the jurisdiction of the Prime Minister's Department, where it receives funding for operations. This leads us to the question, will the MACC be entirely free of any interference from the executive? One of the things that a modern and democratic society prides itself in is the separation of powers. For a country to have good governance and true accountability to the public, there needs to be a formidable system of checks and balances. The division of government responsibilities into distinct branches limits any one branch from being overly powerful. I'm sure that we can see the problems that arise when an agency that is specifically tasked with fighting corruption is not independent one, where instead it is placed under jurisdiction of the executive. This is an unattractive and may even be ineffective model to eradicate corruption, to say the least. The term conflict of interest appears in flashing lights when we consider the lack of independence when the MACC is conducting its investigations. Of course, I'm not saying that the MACC is entirely ineffective. What I see as the problem is that this arrangement raised some serious concerns on the ability of the MACC to curb corruption at high levels of politics and in society. The precarious position of the MACC may expose it to the influence of the executive and thereby hinders its ability to do its work effectively. That's what I mean. There needs to be a stronger monitoring of the executive branch, something that admittedly is still lacking in our country. Success of established anti-corruption commission is their independence from executive interference. Otherwise, such commissions will be ineffective. A good example is that of Hong Kong. Since its establishment, the Hong Kong's Anti-Corruption Agency, ICAC, has operated with an independent status. The ICAC has adopted strong anti-graft strategies that combines law enforcement, corruption prevention, and public education. Hong Kong has consistently ranked among the cleanest economies in the world. This is something we may learn from. It is therefore axiomatic that the MACC must function independently and impartially to be a viable entity to stamp out the scourge that is corruption. The separation of the AG and public prosecutor. The Attorney General, AG, is the principal legal advisor to the government and is also the public prosecutor. The power granted by the Federal Constitution to institute any proceedings for an offence is exercisable at his or her discretion. If we look at our Federal Constitution, Article 145 sub 3 affords wide discretionary powers to the AG. This clearly stands in the way of the doctrine of separation of powers. The Malaysian Bar has on multiple occasions sought for the AG and public prosecutors' offices to be distinct and separate from each other. One of the founding fathers of the United States of America, James Madison, once said, "The accumulation of all powers, legislative, executive, and judiciary in the same hands, whether one, a few, or many, and whether hereditary, self-appointed, or elective, may justly be pronounced the very definition of tyranny." Our view is that when the roles of the AG and public prosecutor are fused, there are potential conflicts of interest that might occur, especially when the individual who is prosecuted is a high-ranking official in the government. From the standpoint of justice, it is crucial that the person who holds the role of public prosecutor must be able to make decisions independently of the executive as a whole. The separation of both the offices of the AG and the public prosecutor will ensure that they are truly impartial and independent from any political influence. But let me give credit where credit is due. In November 2020, the government announced that it was amenable to amending the Federal Constitution to separate the powers of the AG and the public prosecutor. It was reported that the government is committed to ensure the move towards transparency in our country's justice system, an idea first mooted in the Pakatan Harapan Manifesto. However, things are easier said than done. We hope to see concrete steps taken so that progress can be made in order to ensure that criminal justice system in our country are served fairly and without any bias. Ladies and gentlemen, all of us who are gathered here today are members of civil society organizations. We are an aggregate of non-governmental institutions and organizations that represent a wide range of interests. Ultimately, I think we are all here because we want a better society, a cleaner and fairer one that does not put a select few above others. I bring this up because civil society groups, non-governmental organizations, and community-based groups play a pivotal role in the fight against corruption. The United Nations Convention Against Corruption recognizes the role of civil society in this fight under Article 13, where it calls on governments to increase transparency, improve public access to the information, and to promote public contributions to decision-making process. I've earlier on spoken at length about the ways the authorities can prosecute and enforce measures against those who commit offences. But first and foremost, let us not forget that corruption can be prevented. All of us must expect a high standard of conduct from public servants. Preventing public corruption also requires a concerted effort from all members of society at large. Steps that can be taken: preventive policies and enhanced transparency in the financing of election campaigns and political parties. Countries must ensure that their public services are subject to safeguards that promote efficiency and transparency. This is where civil societies matter. We raise awareness and bring to attention the government of the things that can be done to improve the way things are. A well-developed civil society will represent a wide variety of interests. Such varied voices will allow us to see the problem of corruption from different, diverse perspectives to come up with an effective strategy. This is precisely what we are doing here today. All this roundtable discussion, we are using our influence at civil society organization to mobilize strategies to combat corruption. This is a good start. Ladies and gentlemen, we submitted our joint memorandum in 2015. 3 administrations and many promises later, there is still a lot to be done. Significant changes must be done, and many of them require amendments to legislation and structural reforms that take time and patience. We have been patient for many years. What we need now is the political will and sufficient pressure from non-governmental groups to reduce any further opportunities for corruption. What we need now is for our country to have transparent institutions and rigorous law enforcement, as well as independent agencies that are effective and capable. The complexity of these issues demands institutional reform. It is a monumental task, but I hope that these hurdles can be overcome. We are all exhausted from reading about corruption-related scandals on a regular basis. As Malaysians, we deserve better than that. With that, I look forward to hearing from the distinguished speakers about your thoughts on this topic. Thank you, and I wish you a fruitful session today. Over to you, Arif.
Thank you very much, Mr. Kalidas, for those very relevant and inspiring words to start us off for today. So without further ado, we will now begin session 1 of our roundtable, re-evaluating the 2015 memorandum for the reform of the MACC. I would like to invite Ms. Cynthia Gabriel, Founding Director of C4 Center, to begin the session. Over to you, Cynthia.
Thank you very much. Thank you very much, Arif, and to the Malaysian Bar Council President, Mr. Kalidas, for actually highlighting so many of the events that we're going to be talking about today, and so many points, so many pertinent recommendations that have already been made. But let me start by welcoming everyone, and to also thank the two government institutions that are also on board. We have the Legal Affairs Department of the Prime Minister's Department, which the Law Minister actually presides over, and the National Financial Crime Centre. This invitation was also sent to various other government institutions, and we hope that this roundtable will be the first of a series of many discussions, because it is, as Mr. Kalidas said, an unending topic and a favorite topic for some who have been working tirelessly to actually ensure that institutional reforms actually on the table and become a reality. I also wanted to welcome and thank my friends who were all part of the drafting of the memorandum together with the Bar Council. We have representatives from IDEAS, from of course from C4 Center, from Transparency International, and also from the Citizens Network for a Better Malaysia. So kind of deja vu, because we are 6 years down the road. This memorandum was launched, as you can see, on the 11th of November 2015. So we're now November 2021. So after 6 years, we're back to ground zero, or maybe we never moved. But this is why it's really important to revisit this memorandum. And I think while we reevaluate some of the important, pertinent points that we already recommended at the time, I wanted to actually start by taking you back to something even before the efforts of the memorandum, and to put a context on why we decided to actually develop this memorandum in the first place. So back then, before 1MDB and all that, the senator at that time, Datuk Pon Lau, who was a Minister of Integrity in the Prime Minister's Department, was actually reported in the press by saying that the Malaysian Cabinet had approved a proposed amendment to the Federal Constitution to make the Malaysian Anti-Corruption Commission autonomous and independent of the civil service. And the proposal, which the Cabinet had endorsed, was for the MACC to be made a Public Services Commission under the Constitution. So this was a Cabinet decision, but of course it was never tabled in Parliament, because one of the things they spoke about was a two-thirds majority in Parliament that was actually required, and that was going to be a big challenge. But at that time, the Cabinet had approved this. And further to that, according to the news reports, the proposal was also to secure a tenure for the Chief Commissioner for a very specific number of years, and to protect the Chief Commissioner from real political blowback, should he or she choose to investigate high-ranking public officials. And it was also to give the Commission exclusive right to hire and fire its own staff. So these are three very important recommendations that are also covered in our memorandum. So that gave us the impetus to actually do a lot more legal research, to do a civil society memorandum, drafted by the Bar Council, to help push further the reforms around the MECC back in 2015. Now, fortunately, in 2015 also, we had the 1MDB breakout. The same government that promised reforms to the MECC and reforms to the Federal Constitution was also mired in one of the largest financial crimes in history, the 1MDB. And because of the 1MDB, we also saw what happened with the MACC. Very unfortunate events where the leadership was forced to leave. Either they were forced to move on to some other civil service position, or they were actually asked to just disappear. Because there were so many things that happened. We also understand, and we know from history, that in the same day, the Deputy Prime Minister and the Attorney General were sacked because there were some potential charges that were going to be pressed by on the then Prime Minister Najib Razak. And many things then became so pertinent that our public institutions needed so much reform. It was the MECC, it was the Attorney General's chambers, as Mr. Khalida said, it was the judiciary, the police force, and many things. So key to the reform agenda of change in government in 2018 was for institutional reforms. And the MECC reforms stood at the center of a lot of the demands that civil society was actually making. Now, I'd like to take you through a couple of slides that will just help us actually see, in summary, some of the things that we had actually discussed at length. Now, the first is what we have today. The MACC today is directly under the Prime Minister's Department. So it isn't just a perception issue, because the funding for operations also comes from the Prime Minister's Department. The MECC was lifted to a commission from an anti-corruption agency back in 2009. And in there was the need and a pressing point about making the MACC more independent. So currently, we still have 5 oversight panels to actually look at the functions and the workings of the MACC today. Now, what we need to do in this roundtable, which I hope all of you will actively participate in, is to actually look at the effectiveness of these oversight panels and whether they are actually functioning the way it was meant as what was described in the MACC Act, or it actually deserves a whole lot more attention into how it should be restructured and what should actually be done. So this is the MACC today. Now, what is it that we want from the MACC? Is this. So in short, the proposals was first to reform the Malaysian Anti-Corruption Commission and to strengthen it as a corruption combating institution. The second is to establish a constitutionally mandated independent anti-corruption commission headed by a constitutionally recognized and mandated commissioners of the IACC. So what are we talking about? We are talking about a constitutionally mandated new setup called the IACC, Independent Anti-Corruption Commission. And the third was to separate the entities, which is the constitutionally founded IACC and the MACC, which will serve as an anti-corruption agency, which will actually take charge of the operations of combating corruption. So you have the IACC, which is oversight, and the anti-corruption agency, which is the agency that will actually work towards combating corruption. So important to also reiterate here that these proposals were drafted very much in consultation with the MACC. And the MACC had requested the Bar Council civil society organizations to assist them in putting forward comprehensive proposals. So this wasn't something that we were just doing and then we wanted to talk to the MACC about it. The MACC themselves were also working on proposals for reform, and that was something that was very interesting. So where does all this stand? So according to the UNCAC, the UN Convention Against Corruption, Article 36, is where we actually define the basis for why an independent anti-corruption agency is needed. And we will discuss a lot more of this in session 2, where we're really quite lucky today to have the anti-corruption chief of the UNODC to also take us through some best practices and how some of the different countries actually operate with more independent anti-corruption commissions. So, this is the provisions in the UNCAC, that each state party shall, in accordance with the fundamental principles of its legal system, ensure the existence of a body or person specialized in combating corruption through law enforcement. And these bodies needed to be granted the necessary independence. And this is what I wanted to stress. So jurisdictions with similar standing in all the research that was done, we looked at Fiji, Kenya, Swaziland, Zambia, and quite closer to home also Hong Kong, which are very, very good examples. Okay. Now, this is what an independent anti-corruption commission, the IACA, would look like. It would require federal constitution amendment. So you need a 2/3 parliamentary majority for this. The IACC is to be composed of a group of commissioners independently appointed and to provide oversight to the MACC. That is its main function. It is not just another service commission or a public services commission, but it has real constitutional power and has the expanded role and function of setting policy direction in combating corruption and developing human resources of the anti-corruption agency. Okay, so this is how it would look like, and the lawyers that are present today can further elaborate on this, that this is how the Election Commission is also situated as part of the federal constitution, but many can also argue that the Election Commission is nowhere quite close to independence, and there's a whole committee that actually looked at review of the election commission and so on. But to put it as a constitutional commission would be the first step to ensure a more independent MECC, and this is what we were actually advocating, and that idea was actually endorsed and recommended by the government of the day at that time. So the functions of the IACC are very important because it will operate as an oversight and supervisory body. It will be responsible for the appointment, for the promotion and discipline of officers of the agency, which means the current appointment process of the Chief Commissioner and the commissioners in MACC cannot continue the way it is. It has to have a more transparent, accountable process that might even need to include, say, for example, advertisements in the newspapers, so that many qualified persons who are very well resourced on anti-corruption work would be able to apply, and it would then be decided on merit. Now we have a parliamentary select committees that help us on some of these issues, but you will see that there is not enough strength and oomph and political will around this whole issue of public appointments. And the appointment of the Chief Commissioner was also something that was not picked up by the Pakatan Harapan government. In fact, it was the same process that continued despite them making many commitments towards the reform of the MECC. So the objectives, functions of the MECC's current 5 oversight committees would then probably need to be re-evaluated and discharged. And because now you have the IACC, and the IACC is also fully independent. So these are the things that I'm hoping we would have a bigger composition. Then there was this proposal to actually ensure that 40% of the commissioners are from civil society. And when I'm talking about civil society, I'm talking about the broad framework of non-state actors, which involves academia, civil society organizations, think tanks, researchers, many people who have versatile and relevant experience in the fight against corruption. Parliamentary Select Committee on Corruption to propose names for consideration based on a certain set of criteria. And then they will be voted both by the Dewan Rakyat and the Dewan Negara by a simple majority. All commissioners must have security of tenure. This was one of the very important proposals that we submitted because we saw what happened. We saw with our own eyes what happened during the 1MDB. We saw the chief commissioner just removed, just like that. No security of tenure. And it's not an evaluation of whether at that time the commissioner was doing a good job or not doing a good job, but it was about the fact that he could not do a good job to call on the prime minister at the time because he would then be punished, and that's exactly what happened. And so this is actually very important, that security of tenure is key to actually ensuring that a commission is independent and will not have the interventions and influence of the executive. But the term of office has to be only up to 3 years. And the appointment now, because it's versatile, it will have to be a very, interesting set of commissioners, which will need to be staggered to ensure continuity. Okay. Now, just to move on a little bit, because I'm running out of time, I just wanted to express a couple of things, that there should not be impediments to the participation of professionals and civil society members. Recognition of participation will then require that Section 5 subsection 4 of the MECC Act will also need to be changed and amended, because right now it talks about only persons from the public service or from the civil service that could be appointed. So there are many examples that can be used. KPK, Indonesia, Council of Public Transparency in Brazil, and also from the Republic of South Korea. Okay, now this is another important thing, that the commissioners then identify a suitable candidate among themselves for a tenure of up to 6 years. So it could be reappointed for 2 terms. And following that, there were some other proposals about what else to do with the anti-corruption agencies and how to make the MACC a lot more independent. Now, another key issue here is on the financial independence of the IACC and the ACA, that there should be a separate fund for Parliament to determine and designate for the purposes of the IACC, which is oversight, similar provision that is there in the Maldives constitution, as we had researched, and also for that, sorry. Yes, and also that another option is to rely on a Services Commission Act, and to note that the remuneration of members of the current civil service commissions is also something which is incorporated there. So the remuneration, the actual operations should be something which is delivered from Parliament, and it's definitely not the Jabatan Perdana Menteri as it is now. Okay, so in conclusion, I wanted to say that this memorandum for the reform of Malaysian Anti-Corruption Commission back in 2015 also talked about sections of the MECC that require amendment. Those for those of you who are interested to actually look at those, mainly we talked about section 23, which is on gratification and abuse of power, and section 36, because right now section 36 is about going after persons with unexplained wealth or suspicious wealth, and currently MECC cannot open a case purely on the suspicions of unexplained wealth, but there must be already an open investigation in order for them to use section 36. Also, we talked about the need, and Dr. Punita from Bayu will help to elaborate on this final point, that in order for the MECC to be completely functional, independent, and actually performing its task, as Mr. Kalidas said, of really combating corruption without fear and without favor, there are several other acts that need to be amended. They include the Official Secrets Act. This is an act that actually shields corrupt offenders from many transgressions. And this act actually needs to be either completely repealed or make way for a Freedom of Information Act. That's one. Second is for the amendment of the Whistleblower Protection Act. Something else that, because we ratified the UNCAC in 2008, we were compelled to actually have a Whistleblower Protection Act. But those of us who had dared to blow the whistle in one way or another will definitely allude to the fact that the Whistleblower Protection Act absolutely affords no protection. And there are many components of the act that needs to be amended, including the fact that you have to actually go to the law enforcement agency to report your complaint. But what if they themselves are complicit? And now we heard also from Mr. Kalida's speech that there was one example of the MECC officials alleged to have stolen 25 million. That's huge, huh? 25 million. I think that can build a few roads and longkang and maybe even a school or public hospital. But 25 million of seized assets. This is just a sub-criminal investigation of the former intelligence chief, which she had stolen that money from 1MDB and at that time. But now, because the court had already made the decision that she was on a DNAA and she could actually claim back what was being seized. And when she actually tried to do that, then it was realized it wasn't just the money that was missing. Some of that money in millions was actually replaced by counterfeit notes. So we're talking about criminality involved here by officials. And that should send us shivers actually down our spine, because it actually talks about the grave urgency and the need to reform the Malaysian Anti-Corruption Commission. And friends, this is not the only case. We also saw what happened in Johor Bahru when the two MECC officials were brought to court for charges and how they fled in a waiting car, etc. And many more allegations and scandals on social media. Unfortunately, I think after 6 years of drafting the memorandum, we are in a worse position than we were when we started with the drafting. But in conclusion, for the first session, also is just to talk about why we urgently need to come together and why we urgently need to probably rethink some strategies about how to engage the MACC, the government. And we're grateful actually that there's been some announcements by the current law minister that the MACC Act is up for reforms, but we have no idea when and how and whether he's actually going to include us in that whole process of the amendment. But let's keep going. There are several people I'd like to call to assist me in case I've forgotten to add a few pertinent points, because we have representatives from Transparency International, Dr. Mohan, the president of TI, and Ira, who will probably say a few words after Dr. Mohan. So we have about an hour for this conversation, but I just want to give everyone a time of about 3 to 5 minutes for interventions each. So may I invite Dr. Mohan first, please?
Yes, thank you very much, Cynthia. I mean, Cynthia actually covered a broad perspective of why the MACC need to be reformed. And we were very much involved with all of the other CSOs in 2015. And Cynthia is absolutely right. We, over the 6 years now has passed, and we are back to square one. And we hope that these reforms will take place. And I just want to get this simple message across. If you all can recall, when the Teo Beng Hock's case happened, MACC's reputation took a dive. All right. And in 2015, when the chief of MACC and the Attorney General was removed because of the 1MDB case, there was a lot of sympathy for MACC. And come 2018, when after GE14, when the new government came, there was a full drive to charge those who were involved in some of these high-profile cases. And this is where MACC's reputation picked up again. But sadly, what happened the last 2-3 months, when, as what Cynthia has mentioned, when these 25 million went missing, and to hear that MACC officers were also involved is a big blow to MACC. On top of that, we still hear recently some news media has come up with news saying that there were several people within MACC involved in some commercial deals and things like that. And the unfortunate thing is when such kind of allegations are made, there's no clarification from MACC itself. So these are kind of things, perception issues that is going to affect MACC. And for us, MACC is one of our final defense, I would say, when it comes to especially corruption, fighting corruption. Now, if you don't have them, what's going to happen? So it's very important that these reforms must take place. And I think Cynthia has explained very well how this should be structured. And we hope that the presence of members from Bayu, from the Prime Minister's Department, and also others who are here, and I hope some from MACC are here, that we should seriously take this and move forward. If not, I mean, there is really, what hope do we have? So as civil society, we are always ready to give the full support to the government. But I think both sides have to play their part. And just before I end, every year, Transparency International publishes the Corruption Perception Index. Although it's called CPI, Corruption Perception Index, but the measures in the CPI is very wide. It looks at freedom of information, It looks at the commitment of the government for reforms, institutional reforms, and so on. Now, how do you expect our ranking and our score to go up if you don't want to reform? I mean, every year when the results come, if it is good, you keep quiet. But if it is bad, you say maybe we should have our own index. So that is not the way, you see. So I hope the government will look at it seriously and work with us as civil societies. And we are always ready to help, and so that we can move our ranking further. So with that, I would like to thank C4 and also the bar for organizing this. And thank you very much.
Thank you, Dr. Mohan. I think you actually helped to assert a lot of the very important points, and for us to remind the people in authority that there is a lot that needs to be advanced, and we are willing, very willing to be in cooperation with them. So they actually have to also play their part. I think you've actually said it very nicely. Can I now invite the IDEA's representative, Ms. Ira, to just comment? She's a young leader, but definitely one that has picked up and overwhelmed us on some fronts. So we'd like to hear from her and from IDEA's on this, because IDEAS was also the one that initiated this memorandum in the first place and brought us all together, including the bar and the rest of us, to actually start discussing. So Ira, over to you.
Hello, good afternoon, everyone. Thank you so much, Cynthia, for having me speak today. Yes, I completely agree with Dr. Mohan that, C4 bringing this issue of MACC independence back up into the spotlight, I think comes at a really, really important time. I think we all have, read in the news and seen some videos of many instances where the MACC's integrity and independence has been compromised, and of course we see how endemic political corruption in the business sector is in Malaysia. And I think I hope that the conversation that we are having today can really be taken up by at least some of the people who hold the levers of power. And I'm going to just briefly talk about two things. Firstly is about how MACC independence, while it remains the sort of the main pillar of combating corruption in Malaysia, there are actually a few other things that comes along with it. And firstly, I want to talk a bit about the Attorney General's office. So when we started this campaign together back in 2015, 2016, I co-authored a paper about separating the roles of the AG and the public prosecutor. As I think some of you may know, the two roles are fused in Malaysia, which creates great conflict of interest, as the government's legal advisor and also the chief prosecutor is literally is one person. So this is besides the independence of MACC, the conflict of interest in these two roles are also one of the main driving factors to why corruption is very, very difficult to eradicate in Malaysia. And I'm glad to see that there are other groups now, such as Bersih 2.0, that is also talking about AG's Chamber's independence. I think they actually commissioned another paper as well on this topic, which is an important contribution. So I would like to actually highlight this because our MACC does not have prosecutorial powers. So the prosecutorial power still lies in the AG's office, but as we know, this becomes a big problem when the roles there's a conflicting role there with the legal advisor to the government. So I think together with MACC reform, together with whistleblower protection, witness protection, we also need to really emphasize and really think about the structure of the AG's office, which makes it very difficult for him or her to conduct prosecutions independently, especially when they involve very, very high-profile individuals in the upper echelons of power in our society. So this is really important, and we need to see all these reforms as a package because you can't have one without the other, essentially. And secondly, I just want to touch a bit on how I think the climate for pushing for these reforms today, I think, I mean, I know there's been a lot of pessimism, with the Malacca elections and, the sort of political quagmire that hasn't ended in Malaysia. But I would also like to say that I think with fragmentation and, a sort of uncertainty in politics also comes some opportunity. And, ironically, I think that, even the sort of buzzword or the flavor of the day seems to be bipartisanship currently. And, I don't know, I mean, I'm in no position to say whether, politicians are sincere in advocating for what they do. But what I know coming from a civil society perspective is that we need to grab these opportunities. And I do believe that with this current sort of unstable political situation, there are allies, I think, that we can get in pushing for these reforms. So I do have some hope in our younger MPs, more progressive MPs who I have personally met and who have expressed commitment to combating corruption. And I hope that they will put their money where their mouth is and really sort of get involved. If civil society were going to propose an APPG on anti-corruption, or a PSC on anti-corruption, or anything like that, I would urge our young progressive MPs to get involved and do whatever you can to get the word out to your party leaders about how important this is, because a corrupt system does not benefit anyone. Politicians might think yes, it benefits them in the short run, but think about the amount of loss that Malaysia has faced because of millions and billions that's been siphoned off because of corruption. And this is a time when countries all around the world are struggling with how to sort of revive their economies and get people employed and healthcare systems to be rebuilt. So there is no better time to think about the importance of anti-corruption work. So thank you once again to C4 for giving me this space, and I am more than happy to work together to highlight this issue once again. Thank you.
Thank you so much, Ira. Very inspiring and some very key points about the Aegis Chambers, witness protection, and utilizing opportunities now when the politicians are fighting among themselves, etc. So let's move on. I'd like to invite Datuk Ma Weng Kwai. He's a current Suhakam commissioner, and very importantly also to remember that he was part of the Institutional Reform Committee when Pakatan Harapan first took over. So I believe that this entire memorandum was also presented to the Institutional Reform Committee, but after that we don't know what happened. So can I just invite you for a few comments, Datuk Ma?
Thank you very much, Cynthia. I couldn't resist in taking up your offer to join in this session today. I made some alternative arrangements just to be in time for this session. Thank you very much for that very comprehensive report or account of what you have just given us, and also to thank our President AG Kalidas for that for these remarks in the opening speech. I see my good friend General Arshad being present. He was with me together in IRC. Now, you're absolutely right, Cynthia, in that after Pakatan came into office, came into the power, the IRC was formed. There were 5 of us there. And most certainly, one of the chapters of our report concerns the reform of MACC and the whole problem of corruption in the country. In fact, that was under my portfolio at that time. But we did our report, and we talked to all the stakeholders and so on. But unfortunately, and this is, I'm sure General Arshad will agree with me, we tried very hard to get Tun Mahathir to actually make this public. But for some reason, this was not. And up to now, and actually there's nothing there's no obstacle to this being made public even by the present government if they so wish, because we not only have sectors on corruption, but right across the board, the judiciary and the police and everything else that matters in the reform of the institutions in this country. But having said that, I think there is, although it's all gone cold and gone quiet, I think there's nothing to stop the good people like you yourself, Cynthia, in C4, to keep the pressure mounting or to keep it alive, to ask for this report to be made public. I think for people to say this is confidential, PNC, this is all old thinking, because we really need to know the root causes and what are the very substantial recommendations that were made. And this goes right down the route of revamping MACC. But having said all that, I want to just make a few comments, if I may, and that is this. Just speaking as an ordinary Malaysian, a netizen, ordinary person not sitting in Suhakam or any other committees, and that is this, that we are all very well aware, and I think everybody agrees, that corruption in Malaysia today is so embedded. It's almost a curse that we wake up in the morning, we read about this, we live through this, and nothing much is being done to change it. And this is where it's so sad, because we read in the papers about the millions that are being, billions, the billions that are being siphoned off, and Malaysia is, you know, we hit the news all for the wrong reasons. And it is so embedded, it cuts across all stratas of society, not just in the public sector, mind you, it's also in the private sector. Because like they say, these two to tango, and if there's no giver, there's no, can't be a taker, there won't be a taker. Or, well, there may be takers prompting for it, but if there are no givers, then of course the problem ends there. Now, coming to the act itself, and I think a good point has been raised by Ideas, a young lady from there, and also what Bar Council President has mentioned is this, about the prosecutorial powers. As there's now, as you do know now, we have the judicial and legal service. It's a combined service. And this is something that was also considered by the IRC. And I think without going into a report, I think it's public knowledge, this is my personal view anyhow, that I've always advocated for a separation of the judicial and legal service, so that you have the Chief Justice in charge of the judiciary, the senior judiciary, and the Chief Registrar in charge of the lower judiciary, the magistrates courts and the sessions courts. And then you will have the public prosecutor in charge of the prosecutor. Sorry, this is quite a hard word to pronounce. I'm getting very excited about this, because it is really something that needs to have a different head in charge of prosecution, all right? And this person must be very independent, and it cannot be rolled together with the role of the Attorney General, because as we know, the Attorney General is the chief advisor. He advises the government on the law, no doubt. He also advises on policy, yeah, and whatever way forward. So if we can have these three branches kept very separate, judicial service, the prosecutorial service, and the Attorney General's service. Now, why there's a difference, or why it should be kept separate between prosecution and the judiciary is this. As it is now, it is intertransferable. A person in the office, in the judicial legal office, you can be a DPP today. Tomorrow, if you're transferred to the sessions court, you might have your colleague appearing before you, prosecuting in a case, and vice versa. So, and I was part of this service for a good 12 years, and I can speak with some personal knowledge. And that you put officers in a very difficult position, because today you're junior to one fellow, and you make life difficult to him by asking hard questions in a trial. Tomorrow, you might be transferred to his division and you are his junior. So you can see, I mean, it's only human reaction to try not to upset or rock the cart too much. Okay, that's one point. The other point I would like to talk about is the advisory board under Section 13 that we have now, advisory board, and a special committee under Section 14 of the Act. Actually, unless you look at the act and read about them, you hardly hear of the advisory board or the special committee. What is their role? What have they been doing all this while? What kind of advice have they been giving? Yes, there is to be a report to be prepared by the advisory board that goes to the special committee, and then that goes to the minister for laying before Parliament. That's where those words are, lay before Parliament, in both houses of Parliament. And much like the report, the annual report of Suhakam, we lay it before the Parliament. You know what that means? Laying before Parliament means putting it on the table of the MP. That's laying before Parliament. There's no debate. So this is something which we in Suhakam have been advocating for years and say, please, not only lay it before the MP, let the MP open it, give time for discussion, let it be debated. And I think this is something which this annual report under Section 13 and Section 14 ought to be done, so that you have a report and then the MP should be able to debate and ask questions about this. So that will give a lot of effectiveness. So just to conclude very quickly, I think I'm all for the proposition that the MACC should be independent and have its own prosecutorial powers. Yeah, somebody really independent, not part of the civil service even. It could be a non-civil servant that is empowered to carry out prosecutions. Take that job away from the Attorney General, and I think we can see some serious and positive developments. Thank you very much.
Thank you, Datuk Ma. Thank you for those very important points. One is, if I may quickly summarize, you were actually talking about prosecutorial powers of the corruption cases. So there have been two arguments whether MACC should be given those powers, or it should be what we are always advocating, that there should be a separate public prosecutor's office, as Ira from Ideas had also mentioned, and definitely away from the Attorney General. Now, I quickly want to also say that it's very important you mentioned separation of judicial legal services and the advisory board, because right now, there's no accountability around what is the actual functions and KPIs of the advisory board. And with some of the current transgressions that are being reported, it's very much hoped that the advisory board would say something, but it is not the case, you see. So the panels themselves need to be reevaluated. The advisory board needs to be reevaluated. So thank you for that. And now I'd like to invite General Arshad, my buddy actually in fighting corruption, because we're always talking all these high level corruption cases, also a member of the Institutional Reform Committee, so he knows all the secrets as much as Datuk Ma. But can I just have you say a few words, because I understand you have to leave a little bit earlier. General, you're on.
Okay, can you hear me? Can you hear me?
Can.
Okay then. Thank you very much for accepting me to be part of this show this afternoon. And nice to see Dr. Umar, a good friend of mine, and Dr. Mahan to be part of this session here. But I'm speaking not as a lawyer. I'm not a lawyer. I'm speaking like any ordinary citizen. And I've seen the best of this country. I've seen the best of this country, and I've seen the worst of this country. What I see today is the worst of the country. And I have been talking about corruption, 10, 20 years ago, and I got into trouble because of that, for you to know. Now, what's important now, you have had this reform, what I heard from Cynthia just now, since 2015. Now is 2021. It's been 6 years, and you got already changed 4 prime ministers, and nothing is on. Nothing's heard. What I want to see, actually, we don't talk about prime ministers anymore. Do not bother about going to prime minister anymore. We get mass. The people come and support you. I think a lot of these issues are not heard. I have not heard about this issue. I heard when I was in IFC. But generally, the people, public, do not know what's happening. Because this is only confined to a set of institutions. But I think you need to get the mass support. Go down to the people, get the mass media to speak about it. With mass support, I think the government is shaken. Now we claim to be a democracy, but I don't think we are practicing democracy. In the US and the state, issues like this, they go to the streets. That is democracy. But we do not go to the street because we're afraid. We're so afraid to be caught, be arrested. I think we must change the mindset of the people. The people will shake the government. And I am for this. I am for this. I hope, Cynthia, you can do this. Do like what what you call the current club is doing now. The Buster, right? Russell Buster. He's known to everybody now because he used the media to do it. Now I think you have got to get support in the media that is not controlled by the government, of course. Get the media to get involved. Without the mass support, this will not go. I think it's difficult. Do you have already four changes? Najib, Mahathir, Mayudin, and now Ismail Sabri. And what happened to your reforms? I said the mass exercise your democratic rights. Go to the streets. That's what we did in Bersih to get people to get the government to hear what concerns are. And I think it's shameful. I get reports, calls from my overseas friends that what's happening in your country, Ashad. You're so well known before. One of the Asian Tigers, what happened to you? I said, what can I say? I think this is serious matter, Cynthia. You want us to go to the street? I'll go to the street with you. Let's all get together and go to the street. Tell the politicians that we have to change this. Am I a bit too hard?
Right. Absolutely right, General. I think you've said it. We need to bring out our birthday shirts and start walking again.
Do it.
Not. Okay, and I hope you lead the way. Really, you and Dr. leading. Really great.
I'll get Dr. Mars with me. I've got Dr. Mars with me, and Dr. Mahan can join me as well. No problem. If you want to arrest me, they arrest me. I don't have to be bothered. Okay, then, since I have to leave now, I told my friends that I will be late. So thank you very much.
I hope you'll stay with us still, because we now want to hear from the Legal Affairs Department. Dr. Punita is the director, and she is someone who's been an incredible source of support and strength to some civil society initiatives. One of those rare civil servants that are very open and transparent, and we're happy to have her today. Despite her busyness, she has told us that she will still come and say a couple of things, but also around what some ideas have been popped up around the reform of the MACC requires reforms of several other laws and agencies. So over to you, Dr. Punita.
Thank you, Cynthia. Good to see everyone. Dr. Ma, Dr. Mohan. Okay, I think our discussion today, I would just like to raise a few points, Cynthia. As I mentioned to you earlier, I would not be able to comment that much about the MACC Act. However, there are a few issues that I would like to raise which could be related to the functions of the MACC. First would be the Whistleblowers Protection Act, which I think we're working very closely with C4 as well as with TI and of course Suhakam and all. So that is one area that I would like to briefly discuss because we have about 7 enforcement agencies that are tasked at implementing this law, and of course the Legal Affairs Division or BAYU is looking at the policy part. But I would like to commend the MACC because if you look at the 7 enforcement agencies, only I would say majority of the cases were actually taken up by the MACC. And if you look at the statistics also mentioned by our minister lately in Parliament, about 77,073 cases, complaints were received from 2011 to 2020. And out of these cases, only about 536 cases were classified qualified to be whistleblowers, and we don't really know the numbers that actually received protection. So the numbers are really, really small. Although I do appreciate MACC and the rest of the enforcement agencies for their hard work, but I think a lot needs to be done in terms of the Whistleblowers Protection Act. And I'm happy, of course, to also say that Bahayu is working very hard with, I know there's been a lot of delay as well, but we are trying to make the relevant amendments. The issue could be, the issue I would say would either be the act itself is insufficient, there's some inadequacies in the act itself, or even the implementation part. So looking at it, we are looking at a thorough amendment to it, areas in terms of the oversight body, for example, a body just look at the implementation of the whistleblowers protection, because currently the situation is the enforcement agency will receive the complaint, they will then give protection, and they will also investigate, which is an additional burden to the existing workload for the enforcement agency. So we're looking at that as one area. The other thing is internal reporting. You may have companies who can actually accept internal reporting from the employees, for example, in terms of whistleblower protection, and then of course come back to the enforcement agency for protection. So these are certain things that we're looking at. We're also looking at the inconsistencies in the law itself with the penal code, for example, or in the law itself with the sections within the law. So these are some of the areas that we're looking at. So I'm happy that MACC has been working with us very closely. Also, we also have an expert who is actually helping us. Someone who is actually from MACC, who's seconded to a different agency, but he's helping us very closely in looking at some of the areas in this act. Someone who's actually dealt with many whistleblower protection cases. So this is one area. The other area, as you rightfully mentioned, Cynthia, earlier, was the Freedom of Information and the Official Secrets Act as well, which is also closely linked with the whistleblower protection. We are also working, I think, with CIJ, with Center for Independent Journalism, and also with Cynthia yourself, looking at coming up with a freedom of information law for Malaysia. So we're still studying the possibility of either coming up with this law on its own, or whether we need to amend the OSA itself, or for the OSA and independent law to coexist. The OSA and a law on freedom of information to coexist. So these are some of the issues that we are areas that we're looking at. Finally, on my third point is to look at the area of foundations in Malaysia. And I'm saying this because Bahayu, the Legal Affairs Division, is actually governing as the Trustees Incorporation Act 1952, in which we have foundations that are incorporated under us, and most of these foundations are trust. They actually are based on the concept of trust. So they are all trust with trustees and all that. But what happens is that many of these foundations have issues with governance issues. In fact, under Bahayu itself, we have several foundations that are being investigated by the MACC itself. So issues of governance is something that we need to look at. Under us, we have currently about 500 odd trusts. Out of this 500 odd trusts, we have about half of it call themselves as yayasan or foundations. And many of them are actually government funded. So the question is, what happens to the funds? How are the funds managed? These kind of things are issues that we need to look at. And MACC has actually worked very closely with Bahayu also in this. And there are several cases that are ongoing right now, which I would not be able to share, but that is something that we need to look at in terms of political funding as well. Cynthia, I don't really know what happened to that law that you guys were looking at. I think one of our agencies were looking at it. It's not Bahayu for sure. That's another area. And also, we are looking at how the Jabatan Accountant or Jabatan Audit Negara can actually go into these agencies or these foundations to actually audit them in terms of the funds, because you have a fiduciary relationship already the moment you give you receive funds from the government. So how do we actually go in and how do we actually audit them? That is something that we need to work on. And also in terms of the powers of MACC to also go in and investigate, you need to be a Badan Awam, I was told. So we need to also look into that, which the government is looking at right now, because we had a case previously where we were unable to, a foundation, and we were unable to go in to investigate some the malpractice because it was not a Badan Awam. So these are some of the areas that I think we need to look at, and we need to work very closely with MACC and even Bank Negara because of issues of terrorism financing and AMLA and terrorism financing as well. So I think that's all from me. Thank you so much.
Thank you, Dr. Punita. Actually, that was very insightful and comprehensive because you actually told us some of the inside efforts that are still being carried out, and hopefully your hard work will see some kind of results because when it gets to the hands of the politicians, then everything gets a bit confused and complicated, So similarly with the political funding law, Pakatan Harapan had that opportunity to actually pass that bill, but it just got a bit awry because they were concerned with many things. So we're not sure where the bill is, but it is definitely something that we are pursuing with other civil society groups like Ideas, TI, and a few others. But that is another issue. But we appreciate very much you updating us on Whistleblower Protection Act and Freedom of Information. Very important points also about the Auditor General having to have far more power and assertion instead of actually being subservient to the Ministry of Finance, mainly to actually allow Auditor General to move in, and the whole issue of foundations. So we're very happy that because we've also talked to you about the report that we put together and launched through a big research earlier in the year, that Bayu is actually advancing this subject matter. So thank you for that. Thank you so much. I want to now, in the interest of time, because we have about 25 minutes left, to pick up a few more things. I'd like to now invite the representative from Rasuah Busters, this new graft busting movement, civil society movement that's actually causing waves among many fronts. I'd like to invite Mr. Shah Hakim to say a few words because General Arshad has already pushed something around people power and stuff. And can you just share a little bit about your 6 demands? C4 is part of the Rasuah Busters. Can you share your 6 demands and why you think the reform of the MACC is also important?
Thank you, Cynthia. Thank you for inviting me. Rasuah Busters actually started a year ago now, and really the focus is to create awareness among public on the issues of Rasuah, the issue of corruption in government, and to educate the public on the seriousness in the impact of corruption to their economic well-being. Now, as General Arshad has mentioned, it is important to educate the masses, and in fact, we are taking this to the next step where we are organizing a nationwide roadshow starting from the 9th of December, where we will begin with the state of Selangor for that particular week, and from then on we will then continue with every other state for the next 12 weeks. And this roadshow is focused towards educating the rural folks on the problems of corruption, how corruption impacts their well-being, the economic well-being, and also to visit schools and engage with students in schools, as we have done during the Melaka election, quite successfully, I must say, in terms of trying to educate the public of the issues of Rasuah. I'd just like to touch on 2 things. Today, the corruption problem in Malaysia is equal to that of Indonesia and Brazil in its heyday. And, we've heard many horror stories about the issues in Indonesia and Brazil. levels of corruption and how it's embedded in the corporate cultures and so on. Two things that we can really learn from these two countries. From Indonesia is the way that the government made KPK absolutely independent, reporting to a parliament committee. Okay, and that has made the fight against corruption in Indonesia extremely effective. And no need for us to try and reinvent the wheel. A small case study on how that was done and how difficult it was for them to implement it, and how we can avoid the minefields would be beneficial for us to learn from Indonesia. From Brazil, the famous Lava Jato corruption scandal. Lava Jato is actually car wash, yeah. It means car wash, and the famous Lava Jato corruption scandal, which involved the Silva government and almost all the big corporates in Brazil. And it was not possible for this scandal to be unearthed if not for the independence of the public prosecutor. Okay, the public prosecutor was a judge who worked tirelessly, reported independently to the president of the Senate, and had guarantee of tenure, guarantee security of retirement, and so on and so forth. Yeah, and allowed him to go up against the largest corporates in Brazil, putting people that we never imagined would go to jail in jail. Okay, so these are possible case studies that I think would be very useful for us to learn and for us to understand some of the minefields, some of the issues they face in doing the implementation, in carrying out investigations, and as they went through the investigation, the loopholes that they had to work through and achieve. Yeah. So as our level of corruption is today, I would say equal to that of the best, which is Brazil and Indonesia. I think it will be useful for us to spend some time learning from these countries. Thank you, Cynthia.
Thank you very much. Thank you also for confirming the importance of public education and doing so much in schools and the roadshow that's going to happen starting from International Anti-Corruption Day. I think this is a very important aspect of fighting corruption. We need to definitely empower and build the capacity of the people and voters, etc. While some of us are also engaged on the reform agenda, let's also hear from, I don't know if the NFCC wants to say anything. Tan Lee Chu?
Hi, Cynthia.
Hi.
I'm unable to on my camera. Sorry for that. The camera is not functioning. For all the presentation that are presented by few the presenter here, very appreciate on it, and of course I will take note and refer to our KP on this matter for the information. Thank you very much.
Okay, thank you so much for joining us. And for those that are not so aware of the NFCC, it's one of the successes of the reform initiative. So some things do work, actually. It was set up during the Pakatan Harapan time. There's a separate bill that was drafted and passed quite efficiently and fast to set up coordinating agency among law enforcement. So this is the National Financial Crime Center that holds a lot of hope and promise that they would be able to better coordinate information among law enforcement agencies, etc. It's just begun, and I think there might be a lot of opportunity for engagement and for collaboration. So the MACC is one of the key institutions under the purview of the NFCC, and I believe that NFCC's presence here today is actually quite important for us to look at another aspect maybe of the engagement process. So Thank you so much for joining us, and please don't go away because the second part also requires NFCC's observations on best practices of anti-corruption agencies and so on. Does anyone else want to say anything or make any comments? I see there's a few other names here, but before I open it up to media representatives, Dr. Ho, yes, please, you're welcome.
Yeah, Cynthia, thank
Dr.
you for mentioning highlighting this point of this question of unexpected wealth. I think is one of the central things in the Hong Kong the anti-corruption body there, but it's absent in our MACC Act. So that I think is a very important point to incorporate. As you can see that the present politicians and all that, we cannot hold them up because of this question of unexplained wealth. We cannot hold them up. The important thing is that to I think they change the leader is that they should be guilty and put on the orange garb until they're proven innocent. I think that's the way to go about it. Yeah, I think this is a point that I think that needs to be pushed. Yeah, we can see the glaring double standards here. The ordinary man hauled up by MACC, they are garbed in orange, and these other high-profile politicians are exempted from that. So I think these double standards should not be there at all.
Thank you so much. Actually, that's a very critical point that I remember we worked on together on unexplained suspicious wealth. And we're getting more and more civil service high-ranking officials, even among MACC officials on social media and all, it's exploding about suspicious wealth among high-profile officials, politicians, and so on. So there is a limitation under Section 36 of the MACC Act that they cannot just open a case based on suspicious wealth. But we had studied a couple of other jurisdictions, including Hong Kong and India, that may require that whole section to be amended, mainly because we also don't have a asset disclosure or asset declaration law. And I'm just wondering if I can get the input of Datuk Ma, who's also here from a legal perspective. How is it that we can be more effective in tracking illicit enrichment? The Pandora Papers recently had exposed a whole range of world leaders and business personalities, etc., that have been using the shadow economy to enrich themselves, using offshore islands, shell companies, and so on. But back in Malaysia, we have so blatant conflict of interest. Minister of Finance is implicated in the Pandora Papers, but he's basically saying it's not an issue about investments, etc., because it's all legitimate. But at home, there is no asset declaration law or illicit tracking of how they obtain their wealth. Because if the wealth is obtained legitimately, then there's no law that's broken. But because we don't have a law, there's a lot of gray area can be maneuvered to obtain wealth which is illicit. So anyone, but I was also pointing my pointer at Datuk Ma, who's a esteemed former judge and a long-time legal practitioner, about what do you think about the urgency of asset declaration law, because that wasn't highlighted much in most of the previous interventions that talked about so much reforms required in line with the MACC reforms.
Thank you, Cynthia, for that question. As far as asset declaration is concerned, I think this is quite the norm these days, except when it comes to MPs. There's always a reluctance to declare their assets. Judges, for example, the moment they are appointed, the first thing they do is to declare their assets. So this is quite a common thing already. The other, of course, is I think is that emphasis must be placed, or a distinction must be placed between enforcement of the law and having new provisions of the law. This, to criminalize and to make it an offense to have suspicious or unexplained wealth. Yes, if you are going to have that as an offense, but it also depends very much on how these provisions are going to be interpreted and enforced. As it is now, it's not just suspicion of unexplained wealth that's happening, but we do have cases where the evidence is quite clear there's wrongdoing, but yet people are not being charged. So at the end of the day, it's always a question of the enforcement, the investigation and the enforcement that comes with it. And that's why this actually underscores the very important need to have a separate prosecutor for MACC, a separate power given to MACC for prosecutions, take it away from the hands of the public prosecutor. And a person who is fully independent is really, really important. Coming to Mr. Ho's issue about orange garb, I think you have a very good point there as well, because apart from talking about corruption, this has to be translated, action has to be translated into, or rather words should be translated into action, so that the man in the street will see that there's fairness and there's reasonableness. And I most certainly take note of the fact that when it's an ordinary person that's been charged for giving a few dollars to a policeman at a roadblock, he's arrested and then handcuffed, and he is detained and remanded for 7 days, and he goes to court in handcuffs and in the lockup, the orange attire. Whereas politicians and big people, when they are arrested, well, they go to court by appointment, and nicely suited and all that, and that's not part of the process. So to the man in the street, already we are practicing double standards. Why aren't these people also in handcuffs when they are arrested? Yeah. And why aren't they treated the same like an ordinary person who's charged under the Act? So I think we have to come away from this mentality of special treatment for special people. We cannot afford to have this double standards. And I mean, these are general principles. They're not only applicable to the law under MACC, but these are principles applicable to all laws, including the penal code and so on. So really coming to this offenses, and whether we are creating new offenses or just looking at and consolidating the efforts of what the existing law is, I think that is already a major step forward. Thank you. Thank you very much.
Thank you very much. If there's anyone else who wants to make a final comment? If not, I will need to summarize, because we have Mr. Francesco already online, and I will need to actually get into passing it back to Arif to moderate session 2. But in summary, I wanted to thank everyone for highlighting so many important points, that the memorandum has spoken about a lot of nitty-gritties, because we spent a couple of months actually studying the Anti-Corruption Commission's best practice, what is really important to make MACC independent. So I won't go through that again, but I wanted to just talk about highlighting some very important points. One is the willingness of all of us, civil society, even other commissions, to actually discuss with the Legal Affairs Department, the Law Minister, and MACC themselves about pushing this proposal forward. And together with that is to look at the reforms around the Attorney General's chambers, to develop a separate public prosecutor's office which is completely independent, to look at security of tenure of the chief commissioner, to amend the whistleblower protection law, and to hear from Dr. Punita that there are many advances in that direction, of which we are all a part of, which is very, very encouraging. So hopefully there's hope somewhere, taking from the line that Ira mentioned, that there might be hope in political uncertainty and in the younger population and younger politicians who also struggle with the whole issue of political funding, with the issue of the rule of law, better practices in political parties, outside, in parliament, a reform of parliament, and a couple of things that I think Dato' Ma alluded to was very important, which is the cross-link between corruption and human rights as well. Because the more the corrupt practices and the more the allocations and money, public money stolen, the victims of human rights, victims of corruption become very loud because their rights are being violated and taken away from them. So I think this working together with Suhakam on many of these public interest issues and corruption issues are a very important strategy as well, to look at corruption as a human rights issue around business and
Can I
human
just make
rights.
a comment? A quick comment here, Cynthia. I think it's just a quick comment. It's just that, you see, I think we have to get our priorities right, in the sense that, you know, when you talk about billions of money which are being siphoned out, which could be used, made to for use of public good. Just give an example. For Suhakam, you know, we are the National Human Rights Institute, and what is our budget? We have 9 commissioners and we have got 80 staff. Our budget is only 11 point something million, which is so small, and we spend so much of it on paying for salaries, of course, management, and there's not much money left over for operations and for activities and so on. So, and yet, you know, you read in the papers and say, my goodness, so many billions have been lost. I do not know how many zeros there are in this amounts that have been lost. But just a quick comment on that. Thank you.
Thank you. And also to reiterate how priorities are in this country at the moment, because if you talk to MACC, they will also say the same thing. There's just so little money to fight so many corruption cases, and that is a very important issue to discuss. But importantly, that memorandum of reform discussed that funding has to be from Parliament, because the minute it continues to come from our national budget and from the Jabatan Perdana Menteri, then that will in itself compromise the independence of the institution. So there are many other suggestions that were made, including what do you call that, separation of judicial legal services, looking at unexplained wealth, tracking illicit enrichment, and getting into making the Auditor General's office more independent as well. So overall, it looks rather daunting that we don't really know where to start, how to actually effect these reforms. But we do want the politicians and the people in power, the policymakers, to actually hear that so much has actually been done in terms of research and work by civil society organizations, by the Bar Council, by Suhakam and everything. And it is really time for them to actually get their act in order. And I think that is the only thing to say now in conclusion, that the reforms are urgent. The corruption situation, the political uncertainties are certainly not helping with the advancement of reforms. So the second session is actually very important, because we need to look at how other countries have also advanced or regressed, as in the case of Indonesia and all that. And what is it that we need to do to ensure that the Anti-Corruption Commission and public institutions must remain independent? So I now end this first session and hand it back over to Arif to take on the next part of the program. Thank you.
Thank you, Cynthia, and thank you to all of our participants in the first session. I think it was thank you all again for your contributions to the discussion, and I think it's just quite astounding how tirelessly everyone has been working over the past decades even, but it's still so difficult to move the needle with anti-corruption, and I think that's a testament as to how large the scale of the problem is. And taking on the point of General Arshad and also Mr. Shah Hakim on how we need the groundswell to help us put pressure on these politicians. So without further ado, and to keep momentum up, I would like to invite Mr. Francesco Cecchi, the Anti-Corruption Advisor of the UNODC, to give his presentation on insights on the effectiveness of anti-corruption agencies and best practices, and then we'll continue with our Q&A after that. So over to you, Mr. Francesco.
Hello, do you hear me?
Yes.
Okay, great. So thank you very much for inviting me to participate in this roundtable. It's been a very interesting discussion so far, and I must say it's really commendable that so many NGOs, agencies are involved in this very crucial debate, and I want to thank Cinzia in particular for inviting me to speak at the round table. I must say the quality of the debate is really really high, and I really feel in agreement with some of the issues that have been discussed. I'd also understand there must be quite a lot of frustration because of the length of the reform process that is not moving forward very rapidly or not at all. Just if it makes you feel a little bit better, what I can tell you is that in my own country, Italy, we have been talking about separation of the career of the magistrate and the judiciary for almost 20 years. So this is not the only country that you are dealing with this kind of problems. And also, I really very much agree on the point concerning the separation between the role of Attorney General and the Prosecutor General, for example. So very many good and interesting points. I will talk a little bit about what are the principles that the international community has put forward when it comes to the independence of anti-corruption agencies, because I think this is one of the major points. And the UN Convention Against Corruption itself, in the end, does not contain that much. Cinzia has already mentioned a couple of articles, Article 6 and 36, that have reference to that. And in particular, we talk about the fact that anti-corruption bodies have to have the necessary independence. So the convention mentions independence, but doesn't really elaborate in very many details on, how this independence should look like, and also that anti-corruption agencies should have the resources, the specialized staff, as well as the training to carry out their mandate. So the international community has somewhat tried to define these principles, these elements of independence, and came up with the Jakarta Principles. You may have heard of them in 2012, and with another document, which is the commentary to the Jakarta Principles on anti-corruption agencies, that includes several aspects of how anti-corruption agencies should work. And so, for example, the Jakarta Principle, they speak about the mandate. So there's a lot of different types of mandates of anti-corruption agencies. The Malaysian Anti-Corruption Commission actually is quite well known globally for an agency that has extensive powers and that covers various areas of anti-corruption work. And that's generally seen as a good way of organizing anti-corruption initiatives. So an agency that includes both investigation as well as prevention, as well as awareness raising and education work. It is a model that we see in Singapore, we see in Hong Kong, we see in many other parts of the world, and overall is not bad to have an agency like that. Generally speaking, this is to say, not everything is to be completely, I would say, criticized about the Malaysian system. The second principle is about collaboration. So the fact that there must be collaboration with various parts of the system, and in particular the prosecutor office. And I'll come back to that in a minute. The permanence of the anti-corruption agency, meaning the fact that the agency should possibly be enshrined in a law, or possibly even more importantly in the constitution. And then there are principles with regard to appointment, continuity, and removal of the head of the agency. I'll talk about that as well. Ethical conduct of the agency. The agency has to have ethical framework and standards that are specific to the fight against corruption. Immunity. So the immunities have to be there with regard to operational immunity of investigators of the anti-corruption agencies in the conduct of their work. So immunity from prosecution, investigation, both criminal and civil, for their activity. Remuneration, so having appropriate remuneration for the anti-corruption, the staff of the Anti-Corruption Commission. The Commission has to have authority over its own resources. So the authority means the staffing, the appointment, selection of staff, as well as promotion. They all have to be managed independently by the agency. The agency has to have adequate and reliable financial resources and financial autonomy, and I'll come back to that in a minute. There must be systems of internal and external accountability, system of public reporting, and also public communication and engagement. So these are very general. Generally the principles. Now, I wanted to discuss also some of the principles more in details, and in particular with regard to the mandate of anti-corruption agencies. I've heard the discussion that you have held on the issue of the prerogative of the MACC. I have to say that internationally, the MACC is seen as quite a powerful agency, and I was surprised to hear the discussion on the relationship with the prosecutor, because there are analysis of best practices, and MACC is seen as one of the agencies that has good practice with this, insofar as the chief commissioner is also has also the prerogative and the capacity to kickstart investigation, utilize special investigative techniques, and so on, quite independently, and has been given authority by the prosecutor office. So maybe I'm missing some of the details, but overall it looks like the system of cooperation in terms of investigation in Malaysian in the Malaysian institution is not so bad. But the most important part I wanted to cover, and I see my time is running very fast, is the elements related to anti-corruption agency heads appointment, continuity, and dismissal. So First of all, one of the main principles here is that anti-corruption heads shall be appointed through a process that ensures their apolitical stance, impartiality, neutrality, integrity, and competence. So, you know what these principles are about, but in practice, if you look at international standards, there are two different ways of doing this, and there are the single branch appointments, such as in Malaysia, where the king appoints the chief commissioner upon advice from the prime minister, and there are also approaches that instead see the involvement of different branches of power. So, and in particular, the approval by parliament. And if we're talking about reforms of the MACC system, maybe this is one of the things that could be looked at and could be achievable. There are examples, for example, in many countries, there are procedures that involve the parliament in the appointment, such as in Latvia, for example, candidates for the position of director of the Corruption Prevention and Combative Bureau are selected through an open recruitment procedures, in which candidates are required to submit application and assessed against a set of criteria, after which a short list of candidates is produced by a group of experts, and candidates are examined by the National Security Council and interviewed by the Cabinet of Ministers, which submits final recommendation to the Parliament for endorsement, and they have to be endorsed by the majority of parliamentarians. So this is just an example. There are many other examples of agencies that have this type of appointment systems, including Indonesia also has the involvement of the parliament in the appointment system. And also the other important element beside the appointment is, of course, the fact that heads of anti-corruption agencies can often become victim of their own success. So with successful anti-corruption investigation and prosecution, sometimes there is political backlash against the agencies, and you know about this. Two elements are important here to consider. So the fact that the anti-corruption heads shall have security of tenure. So one mechanism to help ensure that the anti-corruption agencies heads are not subject to reprisal for their work is to have the tenure, of course, defined very specifically by the law, as well as the circumstances whereby this tenure can be interrupted. So the removal or dismissal of the head has to be, very specifically established by law. What are best practices here? Generally speaking, of course, that the dismissal should be permitted only in a very narrow set of circumstances. The examples that we have here from many agencies that define these grounds for dismissal include, gross negligence, irregularity or misconduct, or incapability, physical or mental incapability to conduct the work. And there must be also, if there is an allegation of misconduct, the allegation shall be investigated the determination should be made through some form of quasi-judicial process, through a specific procedure, such as involvement of a committee of experts, and so on. And also the anti-corruption head, the head of the anti-corruption agency, and its agency should have the possibility as well as the time to defend himself or herself publicly prior to any decision. So this is also extremely extremely important. So in many instances, when there is a process of dismissal, the legislature again is involved. So this is the case in many agencies. For example, in Sri Lanka, a member of the commission to investigate allegation of bribery or corruption can be removed only by an order of the president made after an address to parliament, where the motion is supported by a majority of the parliamentarians. So again, here there must be a public debate, a debate in parliament, and then an approval of the parliament for the dismissal. Is the same in many other agencies. Now I see that my time is running out, and these are kind of reforms that are extremely important, I would say, for a system like Malaysia. More specifically on the independence of the anti-corruption agencies, there are various levels of independence. So you can look at independence, at the level of operational in activities, operational of the investigators. You can look at the independence in terms of functions of the agencies. And here we talk about independence from the executive and having a very calibrated system of check and balances, because independence also has to be very much equilibrated with accountability. And also oversight has to be very well organized. Oversight, generally, in terms of best practices for oversight, you have two types. You have oversight from judicial bodies, such in many cases where the agencies report to the parliament, or you have in parallel to that, in addition to that, external accountability, reporting to committees, such as the system is in Malaysia. Now we have to see which are the powers of these committees, and it's a very long and complex discussion. But generally speaking, there must be this system of check and balances, and no agencies can operate in absolute independence. That's quite clear. I also wanted the last point is about the budget, because it was mentioned, and the budget is critical because. Of course, there cannot be that much independence without a proper security of financial allocation. So the best practice here would be to have a budget allocated on the basis of the law annually by the parliament, as for any other institution that is a core agency or institution of the state, and of course the budget enough for the activities to be carried out. So anyhow, I will stop here. These are just a few observations for debate, and I would be glad to hear maybe some other observation from the colleagues on the points I made. Oh, thank you very much.
Thank you, Francesco, for sharing that. I think it does give us some assurance that Malaysia isn't alone in the fight against corruption. It's a global issue, and your example of your home country having spoken about that issue for 20 years is I think something that we should take heart in, that we're all in this together. So I think for this session, we'd like to open the floor to any comments or any questions that you'd like to ask Francesco. But before that, perhaps I could start with a question of my own. As was alluded to in the first session, 2015 was 6 years ago, and I think a lot has changed since then. It was before the reveal of the 1MDB scandal. Locally, we weren't expecting political fragmentation as we have today, elections in 2018, one point. And also, of course, globally, you have a sort of shift in power, a shift in the global landscape. So I was just wondering, regionally, what have your observations been in terms of the trajectory of anti-corruption agencies around the region? I know, for example, that in the past couple of years, there have been some sort of encroachment by the executive in Indonesia into the independence of their anti-corruption agency. So perhaps just to give a little context as to where Malaysia places its anti-corruption agency within the region over the past few years.
It's a good question. I've seen many agencies going through cycles where they are created, they get, they receive quite a good support by the civil society, such as the case in Indonesia, but I assume also in Malaysia. And then there is a problem maybe of an investigation at a high level, and there is a backlash, and the agency gets reformed, changed, or the powers get curtailed in one way or another. There's many ways, either through budgetary measure as well as through some procedural reforms. What has been done in Indonesia, it's quite telling. The reforms in Indonesia have been, in my modest opinion, I think this roundtable is not going to be on the record somewhere, right? It's just a roundtable between us, yes, I would suppose, right? So because I don't want to express any opinion, public opinion on the subject, but
I should let you know that there are. Sorry, Francesco. Some of the public are watching right now. So if you would like to hold back any comments, then I think that's on.
Oh, okay. Yes.
Your discretion.
So
yeah.
So I would say that there are, as I say, there are cycles of this kind, and there are various ways in which the agencies, the powers, and the initiatives of anti-corruption agencies can be curtailed. It has been done in many instances. As far as the panorama of anti-corruption agencies in the region is concerned, there are quite a number of very well functioning anti-corruption agencies. Indonesia is still well functioning. Thailand is a quite powerful agency. We have Hong Kong and Singapore, as you mentioned. As it was mentioned, this is a centralized model of agencies. Now, have these agencies been effective? If you look at issues such as Transparency International reports, it looks like the levels of corruption are not going down that much. So there must be a sort of a broader debate on other instruments as well, not only on anti-corruption agencies. One of the things that I wanted to say is that anti-corruption agencies cannot operate alone. And one of the most important pillars of the fight against corruption is actually the police. If you look at a normal country, like Malaysia or any other country in the region, the police has force in the hundreds of thousands of staff, while anti-corruption agencies are at the center of the attention, but they have forces, in the thousands of staffs. So without involving the police and the law enforcement authorities in general in the fight against corruption, it's very difficult to achieve concrete results. And the problems, in my opinion, are not that much in the nitty-gritty of the technicalities of how the anti-corruption agencies in the region function. Overall, they're good enough in terms of investigative powers, capacities. The problems is of nature of pervasive corruption throughout the criminal justice system, and infiltrating in law enforcement authorities, and also the problem of check and balances and the lack of sometimes independence of the anti-corruption agencies to prosecute and investigate, especially high-level cases. So the debate has to be broader. And as it was mentioned in this roundtable, there are many issues around which we have to concentrate our attention. But certainly, we need an institutional framework that is functioning, and I think reforming the efforts for reforming the MACC system may be appropriated in that sense. I don't know if I answered your question.
Yes, no, I understand. I completely understand. Okay, perhaps I'd like to call upon some of our speakers, our guests here today, just to perhaps maybe say a few words, or if you have any questions, perhaps for Francesco, so that we can have some sort of a more fruitful discussion. So, Dr. Mohan, perhaps I would like to call you again if you're there.
Yeah. Well, I don't have a question. Hi, Francesco. Very nice to see you again.
Nice to see you.
I just want to just give a comment as what I said earlier, because Francisco was talking about the MACC and why it's so important, and he also mentioned about other institutions. You see, my view is this: right at this moment, we are at crisis mode. The reason I say crisis mode in the sense that, to me, the last institution, as far as fighting corruption or an enforcement unit or an authority to look after wrongdoings and taking action and so on, the last defense for me was MACC. And because of these recent incidents, this is deeply worrying. MACC. So MACC is one thing, reforming and making it strong and powerful and independent. This is one thing. But Francisco, you're absolutely right, because what about other institutions? What about our immigration? What about our customs? What about our police force? We are still fighting right at this moment. Malaysia, 15 years ago, a Royal Commission of Inquiry was held, and they came up with a very comprehensive report to have what we call the IPCMC. And two governments have come, three governments actually have passed through, and until today, this has never seen the light at the end of the tunnel, and they have come up with another diluted version of what we call IPCC. So you see, for the country to move forward, and as I said earlier, related to the corruption perception index. If you are just looking at just MACC, that alone is not about reforming the institutional reforms. It has to be a very holistic thing for Malaysia to look at. And this is really worrying, where we are today. We are today talking about reforming MACC, but what about the other institutions? I don't want to sound pessimistic, but I think we, as a nation, we have to come together, and I think a complete reset is required. I mean, 5-6 years ago, when this whole proposal was given, and where we are, like Cynthia said in the beginning, we are practically back to square one. All those bullet points she highlighted in the slides early in this forum today, nothing has really materialized. So really, while we are having this roundtable discussion, I hope this can be put forward again to the government. I'm glad Dr. Punita is around, and some of you are around. This message should go back to the government and tell them that, civil society are always ready. We are ready to work with you, but you need to have that will to make the change. If not, we'll be sitting here another 5 years later talking about the same thing. So that's my comment. Thank you.
Thank you, Dr. Mohan. Yes, Francesco, any thoughts on that?
I mean, again, as I said before, it's this type of reforms are very difficult anywhere, especially type of reform. If you're talking about, as I mentioned before, the separation of the career between magistrate and the judiciary, the reform of the institutional framework when it comes to, the positioning of the Attorney General. These type of reforms are probably, in my opinion, from a broader perspective, something that makes sense. And again, I'm not expressing, a criticism or judgment of the Malaysian institutions. But if you look at the necessity of having a well-functioning criminal justice system, this probably, from a broader perspective, would make sense. But this type of reforms are exactly what we should be talking about, and because they refer to the system. So you see, the problem, 90% of the time, the problem are in the system. They are systemic, and many anti-corruption practitioners make the mistake of thinking that by reforming just one institution and by looking at one institution, you can really make a difference in the fight against corruption. It's not like that. And as I said before, the whole criminal justice system has to be aligned, well-functioning, and cooperating into a system that allows investigation, prosecution, and adjudication of corruption cases. 90% of the time, if there is a problem there, is not a problem of one institution. It's a systemic issue. And this type of reforms are probably what is needed. Again, I think that the Malaysian Anti-Corruption Commission is overall, in terms of power, in investigation capacities and competencies, if you look at the international panorama, is not bad. I think it's quite a good setup. It just has to function in the system. So obviously, if they investigate cases and then, some of the cases are not prosecuted for maybe political reasons or pressures or interferences by other agencies, then there is a problem which is systemic. And these are the observations that are very relevant here, I'd say. And I wanted also to build on what Cinzia was mentioning about the issue of asset declarations. It is indeed quite important to have an asset declaration system that requires public officials, especially high-level public officials, to report on their wealth, assets, and interests, and then allow investigation on the basis of this system. Many agencies are going in that direction. For example, the Thailand Anti-Corruption Commission, the National Anti-Corruption Commission, can open an investigation only on the basis of misreporting or incongruent data in the asset declaration, or something in the asset declaration that does not add up, or that is not in line with what is observed with regard to the lifestyle or wealth or assets of a specific individual. And they can do so even if they don't have a criminal case, because maybe it's difficult to build an illicit enrichment case. They can build a confiscation case, civil confiscation case against the public official. So, also utilizing other mechanisms like civil confiscations for forfeiture of unexplained wealth, in this case, could be a very powerful add to the system. Because the criminal investigation way sometimes is very complicated, and gathering the evidence, the threshold for evidence for criminal cases is higher than civil cases. So having a set of tools in your toolkit to fight against corruption that is broader is also very important. So yeah, I would agree with Cinzia. Also on the issue of whistleblower protection, extremely important. We have been advocating for that for quite a long time. The fact that there must be, protection of whistleblower must be ensured, and obviously the information has to be utilized properly to open investigations promptly, and the whistleblower has to be informed, and so on. So. And protected, of course. So yeah, all these are reforms from a broader perspective that I think in Malaysia would make quite a lot of sense.
Thank you, Francesco. I'd just like to remind our guests, if you have anything specific that you'd like to ask or anything, you can always raise your hand. But perhaps I'd also like to maybe invite Mr. Shah Hakim, if you're there, to maybe say a few words. If not, it's okay. How about Andrew? Andrew,
I
are
have
you
a
there?
question.
Oh, sorry. Yes, we'll go with Mr. Shah first, and then we'll go to you, Cynthia.
Okay.
Oh, nothing. Okay.
Go
Yes,
ahead, Cynthia. Sorry.
Yes, Cynthia, go ahead.
Oh, what happened to Shah? You're the Raswa Buster. Okay, no. My question is, I think we need you to help us, Francesco, but maybe to tell us how to strengthen civil society's capacity in addressing these different issues. So some of the reforms that we're talking about are about the criminal justice system, and whether there's some programs or initiatives in UNODC that could benefit Malaysian civil society, in terms of resources or trainings or publications or anything you think would actually assist us in becoming more effective stakeholders, because we are an effective partner, but the one that's often ignored or cast aside. Although Article 13 of the UNCAC a big part, a real part of fighting corruption. We're the ones that are usually left out of the discussions on the policy table, on actually in conversation around how reforms can be effected. But at the same time, we're doing so much research outside, etc. So I see the UN ODC as an important bridging agency, actually assist civil society scale up to make these interventions a lot more, evidence-based, a lot more full and insightful. I think if you could just share in the remaining minutes that's left, if there's any options for us to consider about how we could consolidate better our efforts.
Well, thank you very much, Cynthia, for the question. And I wanted to highlight for the civil society colleagues that are present here that we have actually two projects that we are starting right now. One is with the kind support of the United Kingdom. We are going to design and develop a series of trainings in the area of investigative journalism for in particular for the fight against corruption. So investigative journalists are, we have seen in the media, in the news, we have seen with the recent investigative scoops that basically they are essential and extremely important when it comes to highlighting corruption cases, reporting them, and making sure that the right information reaches the right audience. Sometimes which are the anti-corruption agencies or the law enforcement authorities. Sometimes the broad public. So we want to give to investigative journalists, to media outlets, to also maybe some young students, university students that are interested into the subject, the skills, the capacities to not only identify corruption cases or fraud or mismanagement and being able to write a good article about it, but also to understand, which are the legal frameworks within which they have to operate, what are the things that they can do, that they should not do, when any information should go to the law enforcement authority, when it should be instead, when it could be part of a media, of an article, what are the implications in terms of their own security in doing this kind of work. So all these issues, and we're going to address this through a short project, a project in which I hope that all of you will also participate. That will see us conducting a number of trainings in this sense. And the second initiative that I also wanted to mention is funded by the Siemens initiative. It's a global project, and it is about developing better capacities of, in particular, medium and small size enterprises to conduct due diligence and to comply with the requirements of the law, in particular with regard to the new Section 17 of the MACC Act, on the liability of legal persons. And what are the implications of this? What are which are the various elements of compliance that the medium and small size enterprises should take into consideration? So we're going to have here, a study research, as well as, again, a number of training involving potentially also the agencies and the NGOs that are present here today. So that's the other part of our project that can, in a way, involve the NGO. We have also other initiatives active in Malaysia, so we work with the MACC as well as hopefully with the GACC and other agencies, on training and investigations. And when we can, we also, of course, involve the NGOs. So there may be other chances for us to cooperate in this framework as well. So yeah, I hope that these are interesting for the time being. So we will work with something bigger, hopefully, in the coming future. As UNODC, we don't really have that much of an anti-corruption presence in the country, but we'll try to have also somebody there soon. But UN agencies have colleagues as well. So, but thank you for the question.
Thank you, Francesco. I think we'd all definitely be on board with any more collaborations with UNODC. All of us here today. It's very exciting. Sorry, Mr. Shah, I interrupted you earlier. Did you want to add any comments for today's discussion? Perhaps not. Okay, maybe he's changed his mind. Francesco, I know we had a little, we've only got a little bit more time, only about 5 more minutes, but we did have to maybe cut your presentation short earlier. Is there any other comment or any other part of your presentation which you would have wanted to elaborate on, given more time?
No, I think the essential elements are there. I think the discussion was really interesting, and I thank all of you for listening to me and for the patience of listening to me. And yeah, I look forward to working with you in the future if possible.
Thank you. Perhaps, yeah, maybe just a final round if anyone else has any final thoughts. Mr. Shah, I see that you're back. I'm sorry to go back to you each time, but if you have anything extra to say, I just wanted to check.
I don't have nothing from me. Thank you very much.
Okay, thank you. If there's okay, thank you. If there's anyone else, Cynthia, perhaps any final thoughts for today?
No, I think I said so much and I talked too much. But I did want to thank Francisco for joining, because that really helped also put into context the struggle and the enormous challenges of actually developing an independent anti-corruption commission, which is key, central to fighting corruption. So in our platform on Rasuah Busters, which TI Malaysia, C4, and a few other groups are in, that's one of the key demands, actually, is to make institutions independent. And the institutions that we're targeting are actually the Attorney General's Chambers, the MACC. So that's critical in our fight against corruption. But I just wanted to end also by saying that reform that we suggested in that memorandum in 2015 was at the request and consultation of the MACC. So I hope that they are still also pursuing this. And this is something that we will need to work with the Legal Affairs Department and the Law Minister to ensure that it happens. So the assistance of the UN ODC would be of tremendous help also in technical support, whatever training or capacity building initiatives that are needed to actually move this so that politicians are also aware that this will benefit them. I think the narrative has to be that this is going to be something that will benefit the country, and it is in the interest of everyone to actually make these changes happen. So it's a long haul type of work, not something that's going to happen tomorrow. So we've been in it for 6 years, and some activists much longer. before the memorandum and before 1MDB, etc. But I guess we'll have to keep plodding on. Thank you again
Thank
to
you,
everyone for
Cynthia.
reaching discussion.
Thank you so much,
Thank
and
you.
looking forward. You can count on our support.
Thank you.
And good to see
Thank
you.
you.
Thanks a lot.
Great. So today, I think with that, I will end today's session. Thank you again to our guests who stayed with us the entire time, and also, of course, to our speakers. It's been a fruitful session, and with that, good evening and have a great weekend. Thank you.